Today is our second class on civil procedure, and in this class I want to cover joinder of parties, particularly FRCP 19, which is a compulsory joinder rule, and secondly, to cover the res judicata and collateral estoppel issues. The question which we will be using for FRCP 19 type joinder is from the July 2000 bar, Big Corp, M Corp, and Paul. Let me tell you a little bit about FRCP 19 and then let's do this question. FRCP 19 is a compulsory joinder rule, and the basic idea of the rule is that there are some situations where another party really ought to be joined in the lawsuit. There are situations where the plaintiff has sued one defendant, but in fact, in all fairness and in the interest of all kinds of things, they should have sued them both. For example, if you are a adverse possessor and you now claim ownership of Blackacre by adverse possession, and it was previously owned by two joint tenants, and you bring a suit regarding this issue and you only bring in one of the joint tenants, you can see that you really should have named them both. And there are lots of other situations where you really should have joined both parties. And so what Rule 19 is about is two things. One is to identify those, we need a rule for identifying the situations where a party ought to be joined. In all fairness, it just makes sense to join that person in the lawsuit. If you don't join them, either they're going to get messed up in some way, or the people who are already in the lawsuit are going to get messed up in some way. And so you really ought to join this other person. And so the first part of Rule 19, in fact, FRCP 19A, what that rule really does is to identify, give you a rule for identifying the people who ought to be in this lawsuit. Ought to be. You don't get thrown out of court if they're not there. It's just that they ought to be there, and so you go get them if you can. These people are sometimes called conditionally necessary parties. There are all kinds of funny names for them, but the important thing is don't call them indispensable, because they're not indispensable yet, because you might be able to dispense, to proceed without them. So the 19A identifies those people who really ought to be in the lawsuit because it makes sense in the interest of not messing up people. And secondly, you should then go out and get these people and bring them into the lawsuit. But let's suppose you can't. Okay, you can't bring them in because they have diplomatic immunity and you can't sue them. They're overseas and you can't find them. You can't get jurisdiction over them in this jurisdiction. So for some reason or other, you just can't get them into the lawsuit. And now that it's impossible to get them into the lawsuit, what do? Well, this is what 19B is about. 19B says what we have to do in that case is to make a determination as to whether or not the person is indispensable, not just necessary, or so-called conditionally necessary. People use both languages for the 19A people. By the way, the code in 19A, FRCP 19A, doesn't call them anything. It doesn't call these people who ought to be in the lawsuit. It doesn't call them conditionally necessary. It doesn't call them necessary. It does not have a label for them at all. So writers put all kinds of labels on them. These labels come from the history of this area, where those people used to be called necessary parties, and sometimes that language has continued. So the 19A person really has no name, but you'll see lots of names for them. The main thing is that they have been identified by Rule 19A as to somebody that you must go get them and put them in the lawsuit if you can. Okay, if you can. But suppose you can't. And that's what 19B is about. If you can't, now we have to decide, can you go on without them? Or are these people truly indispensable? And 19B has some factors, 4 factors that you are to take into account in deciding whether or not you can go on without this person. If, when you come out of using those factors, if you decide you cannot go on without this person, that person is truly indispensable. They're not just necessary or conditionally necessary or ought to be in the lawsuit, whatever you want to call that 19A stuff. But they are indispensable. You cannot proceed without them. And so you use these factors in 19B to determine if the person is indispensable or can you go on even though they ought to be there, but you can't get them there. So that's what these compulsory joinder rules are about, 19A and B. And let's talk a little bit more about what the rule says, how the rule goes about accomplishing those goals we just talked about. The 19A rule basically says the following. It says, who are the people who really ought to be in this lawsuit? Okay? And we're going to use this, we're going to identify them. So who are the people who ought to be in this lawsuit? 19A says the people who ought to be in this lawsuit are the people who, if you don't get them into the lawsuit, they're going to mess up somebody. Okay, now I want you to actually go and read 19A, because that's really important. And you take my description or your outline description or your Hornbook description, read the code itself, please. It's really important. So what 19A says, it's a long code section, and you need to read it all. And what it says, in effect, is that the people who ought to be in this lawsuit are the people who, if you don't get them into the lawsuit, they're going to mess up somebody. Now, the code doesn't say mess up. It says prejudice their rights or something like that. But you get the message. So if you don't get them in here, they're going to mess up somebody. Therefore, they ought to be here, or they're conditionally necessary. How do you decide if they're going to mess up somebody? What do we mean by they're going to mess up somebody if you don't get them here? Well, the only somebody that they can mess up are 3 people. The 2 people who are in the lawsuit and the person who is being left out. And so the way you can mess up the people who are already in the lawsuit, or you mess up the plaintiff in the lawsuit if the plaintiff cannot get an adequate relief without this person. If the plaintiff can't get adequate relief without this person in the suit, then they ought to be there. You're trying to get ownership of Blackacre and you're suing only one of the joint tenants. Well, you're not going to get adequate relief without suing them both. So that you can't get adequate relief without them. That's how you might mess up the plaintiff. You might mess up the defendant, because if the defendant is now subject, the defendant may be subject to double recovery, for example, where you recover from the defendant and then somebody else got a right to recover from them also. So somehow or other you might injure the defendant by exposing them to either inconsistent results or double recovery. Okay, and that makes sense. That's how you might injure the defendant in the lawsuit. And then the person who is being left out of the lawsuit, if you leave them out of this lawsuit, does that mean that at some later time it's going to become more difficult for them to assert their rights for some reason? And if you're making it as a practical matter, not as a theoretical matter, but for example, double fees to the law firm that's defending or prosecuting the case for you. Well, it doesn't change the theory, but as a practical matter, that really has doubled your cost. So the way you can mess up the people who are being left out of the lawsuit is you might prejudice their rights in the future, where now it's going to be harder for them to get recovery because they should have been in this lawsuit. So the basic rule then is that 19A says the people who ought to be in the lawsuit are the ones where if you don't put them there, it's going to either mess up the people in the lawsuit or mess up the person being left out. And instead of mess up, you can use the word prejudice the rights of the people left out or the rights of the people in. The way you prejudice the rights of the people in the lawsuit, the plaintiff cannot get an adequate relief. The way you prejudice the people, the defendant, is that the defendant may be subject to inconsistent or multiple judgments against them. Now, so that's what 19A says, and it identifies those as the people who ought to be in this lawsuit. So the next thing is, then suppose you can't get them in there. This person, as I mentioned, you can't get them into this lawsuit for some reason. For example, if you get them into this lawsuit, it will destroy diversity. Therefore, you can't get them into this lawsuit. You can't find them. You can't, if you found them, you can't get personal jurisdiction over them for some reason. All that sort of thing. So the question is, if a person is necessary under 19A and you can't get them into the suit, how do you decide if you can go on without them, or are they truly indispensable, cannot go on without them? And the four factors that you use to make that decision are, number one, how much, whoever is going to get prejudice out of a 19A person that was identified, how bad is that prejudice going to be? How much are they going to be injured? Because the injury to whoever the injured party is might be so slight that it really doesn't make much difference. You can almost always find some kind of an injury. So, first factor in 19B, and you should memorize these factors. And by the way, the California rule and FRCP 19, there's no important difference between them. The wording is a little different. The wording is awfully alike, first of all, but there are some differences in the wording, but the meaning is essentially the same. So this compulsory joinder rule is pretty much the same under California and the federal rules of evidence. So back to 19B, the first factor in deciding if you can go on without this person is how much has the injured person going to really be injured. Number two is, can the court find a way, carve out a remedy, to use the language of the code? Can the court find a way to carve out some kind of a remedy so that the person being left out won't be hurt so much? And maybe there's a way to minimize the harm that's being done to that person so you, in good conscience, can go on without them. By the way, in 19B, if you want to quote this, if it comes up on the bar exam, what 19B says is, now that we have identified the person in 19A as they ought to be in the suit, the question becomes, if you cannot get them into this suit because it would destroy diversity or can't find them or whatever, if you cannot get them into this suit, then can the court proceed in good conscience? Good conscience is a term that's in the 19B rule that I want you to be aware. Can the court proceed in good conscience without this 19A person? And two factors so far are how bad are they going to be hurt? Can the court minimize the hurt in such a way, or minimize the injury or harm in such a way that you can proceed in good conscience without them? Now, factor number three, can the plaintiff get an adequate relief without this person? If the plaintiff cannot get adequate relief without this person, it's kind of no point in the plaintiff proceeding with the lawsuit. You go through the lawsuit and it's all over and you haven't got much. And so the third factor is, can the plaintiff get adequate relief without this person? And the fourth factor is, if the court dismisses this case because they find that the missing 19A person is indispensable and cannot proceed in good conscience without them. Good conscience is an important term here. Cannot proceed in good conscience without them. So the fourth factor is, if the court dismisses, does the plaintiff have someplace else to go to proceed with to try to get their rights? For example, if they are in federal court, if we dismiss in federal court, they can go to state court. Well, that would be another place they could go, or maybe they could go to a different federal court someplace else that can get jurisdiction over the party that you need. So the fourth factor is, if the case is dismissed, does the plaintiff have some other forum where they can proceed to get a remedy? So those are the four factors in 19B. So in summary, 19A identifies the people who ought to be in the lawsuit Because if you leave them out, they're going to prejudice somebody's rights, either the people in the suit or the person being left out. The 19A tells you how to identify those people. And 19B and 19A says, once we've identified these people, 19A says you must go and join them. It's not that you can join them if you want to. You got to join them, okay? But you got to join them if you can. But if you can't, then what? Then you got to decide: are they truly indispensable, or we just would like to have them here? And then you use those 4 factors in 19B to make that decision. Now, one of the strategies, in fact, the most common strategy that's used on the bar exam for testing this rule is a case where a situation, let me make the image for you, a motorcycle repair shop is being sued by a customer for defective product, product liability suit, harm caused by an allegedly defective product. So the customer is suing the motorcycle retailer, and the motorcycle retailer, and it turns out that the nature of the defect on the motorcycle, if it was one that was in the design, so it really came from the factory. The retailer didn't cause it. But now, so the customer sues the retailer, and the retailer says, gee, you should have joined the factory in this lawsuit. And so the question becomes, is the factory a person who really ought to be in this lawsuit under 19A? Well, let's see. If you leave the factory out of, if the plaintiff leaves the factory out of this lawsuit, is the plaintiff going to be able to get adequate recovery without them? Probably. You know, I mean, it depends on how much they're suing for, but they chose to leave them out, so they apparently think that just by suing the retailer, they can get adequate relief. So the plaintiff apparently is satisfied with the relief that the plaintiff thinks that he or she can get from the retail motorcycle dealer. So the plaintiff can get adequate relief without the manufacturer. And if you leave the manufacturer out, is the manufacturer going to be subject to inconsistent recoveries? Or, well, no, the manufacturer, manufacturers are part of being left out. If you leave the manufacturer out, are their rights going to be prejudiced at a later time? I don't know. If you sue the retailer and win, and now the retailer tries to get that money back from the manufacturer by an indemnity suit, well, the manufacturer could still defend, saying the motorcycle was not defective. If the customer sues the retailer and loses, then of course the manufacturer still might be sued, but wouldn't be hurt by that first lawsuit. And finally, if you sue the manufacturer and sue the retailer, you sue the retailer and win. See, the real problem, let me quit going through all that and tell you what the real problem is. If the customer sues the retailer and wins, so that the court says the motorcycle was defective, and now the retailer says, well, I'm going to try to get my money back from the manufacturer. So the retailer sues for indemnity against the manufacturer, and now the manufacturer wins, so that the retailer has paid out the $100,000 to the customer, and when they try to get it back from the manufacturer, they can't prove their case against the manufacturer, even though the retailer lost the case against the customer. Now you might say, well, what about res judicata or collateral estoppel? Well, the manufacturer was not a party to the suit, so res judicata won't apply, and collateral estoppel does not apply because it applies to the party against whom the doctrine is being applied has to have been a party to the prior suit. In other words, if you sue you sue a person in a lawsuit, and then they lose the lawsuit, and now you sue them again about some related matter, and in the first lawsuit you prove that that person ran the traffic light. But in the second lawsuit, for some reason, whether or not the person ran the traffic light becomes important, and the person has already lost that issue. Well, the party against whom you're applying the doctrine had a chance in that first suit to defend on whether or not they ran the traffic light. So that will be held against them in the second suit. They are collaterally estopped in the second suit to deny that they ran the traffic light. Well, the collateral estoppel applies, but applies to a person who was a party to the prior suit against that person. Well, if the customer sued the retailer, the manufacturer was not a part of the suit. And so if the retailer lost the suit saying the motorcycle is defective, and now the retailer tries to get indemnity from the manufacturer, they can't say, manufacturer, the court has already decided that the motorcycle was defective. And so you are collaterally estopped, manufacturer, to deny that the motorcycle was defective. That won't work. And that won't work because the manufacturer was not a party to the prior suit. They've never had a chance to defend on whether or not the motorcycle was defective. So collateral estoppel and res judicata won't help at all. So you're now in a situation where the motorcycle retailer may be subject to inconsistent results, inconsistent conclusions from the court. This is the way Rule 19 is almost always tested. The last 3 times it's been tested. It's been tested in exactly this way. And they can test some of the other factors. This is the way it gets tested. It's been tested. And so the consumer sues the retailer loses, court says the motorcycle was defective, and now the retailer tries to get the money back from the manufacturer, and the retailer loses, and this court says the motorcycle was not defective. So now you have the retailer subject to inconsistent results. And the retailer then might say that when the customer sues the retailer will say, gee, customer, you should have also sued the manufacturer, because if you don't include the manufacturer in this lawsuit, then I, the retailer, will be subject to inconsistent results, inconsistent judgments. And so therefore, to prevent this, you, the customer, should have sued us both, so we don't have that problem. The answer to that is that the customer did not sue them both, and the retailer is saying that the case should be dismissed because the customer failed to join an indispensable party. Well, is the manufacturer really indispensable? Well, the question is the manufacturer a person who ought to be in this suit? Sure, it'd be convenient to have them there. Can you proceed in good conscience without the manufacturer in the suit? By the way, the reason the manufacturer ought to be in the suit is because it might subject the retailer to inconsistent results, as we talked about, inconsistent judgments. And so the manufacturer ought to be in the lawsuit. They are conditionally necessary, if you want to use that language. But when you try to get the when the question becomes, is the manufacturer indispensable? Well, the manufacturer is indispensable if the court cannot proceed in good conscience without the manufacturer. Well, the court can proceed in good conscience without the manufacturer, because if the retailer is that concerned about getting inconsistent judgments, the retailer can solve the problem very easily. Under Rule 14, the retailer can simply implead the manufacturer. And if you implead the manufacturer, you get them into the suit right now. And to implead the manufacturer, you don't even need separate subject matter jurisdiction. Rule 14, the impleader rules are like that. The retailer can implead the manufacturer even if they're in the same state. they live next door, if the amount is less than $75,000, any of those things. It doesn't matter so far as subject matter jurisdiction is concerned. All the retailer has to do is to get personal jurisdiction over the manufacturer. That's not hard to do because then they got a big business going someplace. And so the court, if the customer sues the retailer and does not sue the manufacturer, is the manufacturer an indispensable party? Answer, no. No, because the manufacturer is a necessary party under 19A, but they're not indispensable under 19B because the court can proceed in good conscience without this manufacturer, because the retailer is the one complaining that I may be subject to inconsistent judgment, but the retailer can solve that problem very easily just under Rule 14 and plead the manufacturer. And so the last 3 times that compulsory joinder has been tested, that's the way it's been tested, and you'll see that coming up in today's question. Now with that in mind, let's take a look at the question that involves those issues. The question that we're going to look at is from the July 2000 bar. It's the Big Corp, M Corp, Paul question, and so let's take a look at that question. Let's put a diagram on the board that helps us see the fact pattern. In this problem, we're beginning at line 6. Sorry about that. I got it. In this problem, beginning at line 6, Big Corp is incorporated and headquartered in State B. Okay, and so here's State B. And Big Corp is located here. So Big Corp is incorporated and headquartered in State B. Now the reason I told you both of those things is because you and I know that corporations have 2 places of residence, so to speak, for subject matter purposes, for subject matter jurisdiction. They have 2 places of domicile. The corporations are domiciled in 2 places. Those 2 places may end up being the same state, but it's 2 different reasons. They're domiciled in the place where they are incorporated, and secondly, they're domiciled in the place where there is their principal place of business. Place where incorporated and principal place of business. And since the corporation is domiciled in both of these places, when you're trying to get subject matter jurisdiction in a lawsuit and the corporation is one of the defendants, or even if they're one of the plaintiffs, they have 2 places of domicile, and so if you need diversity, you got to take that into account, that the plaintiff who is suing the defendant corporation must be diverse from both of these places of domicile of the corporation. The principal place of business, as you know, is either the place where the so-called nerve center or muscle center. The muscle center is where the corporation has its principal place of business, like maybe Detroit for automobile manufacturing. Okay, that's the muscle center. And the nerve center would be where the headquarters, where the brains of the operation are located. And if the corporation has a big muscle center and it's obvious and easy to identify the muscle center, then that corporation then that's the second place of domicile. Principal place of business is where the headquarters is. The problem is the principal place of business is where the muscle is. So if you know where the muscle is, that's also the principal place of business. That is the principal place of business. Let me back up for a second. Corporation has two places of domicile. One is the place of incorporation, and second is the principal place of business. There are two ways to determine the principal place of business. One is the muscle test and the other is the nerve test. The muscle test is where the main manufacturing facilities are. That would be Detroit, maybe for cars. The nerve test would be where the headquarters is. Now, the general rule is that if you know where the muscle is, you use the muscle test. But a lot of times, a corporation don't have a single big place of business. They have lots of little activities going on in lots of states. So there is no one place that is the central place. An oil refinery might have one place, but a series of restaurants might not. And in that case, the principal place of business, rather than using the muscle test, since there is no muscle, you use the nerve test where the headquarters is. And here, Big Corp is incorporated and headquartered in State B. Now, we presume that we're not using the muscle test to determine its second place of domicile. You might mention that, because you don't know where most of the manufacturing takes place anyway. Secondly, line 6. While in State B, Paul, a citizen of State A, so let's see, Paul lives over here in State A. So Paul lives here, but Paul was visiting State B, and while in line 7, Paul was severely injured by defective fall he had purchased at a store owned by Big Corp in State B. And so Big Corp is here, Paul is here, he got a saw from these people. There's the saw blade, here's Paul. And Paul is injured by the saw. Now, Paul bought a product liability suit for $100,000 against the Big Corp in federal district court in State B based on diversity. So our first lawsuit here, our first lawsuit, we'll put it over here, is Paul versus Big Corp. And this is in State B federal court based on diversity. And this looks okay because Paul is a citizen of State A and Big Corp is a citizen. Let's put this in here so you can see for diversity purposes this looks okay. Paul is a citizen of State A. Big Corp is a citizen of State B. And the amount they're suing for is $100,000. And so that's more than the $75,000. So it looks like the court has subject matter jurisdiction in this first lawsuit. Paul versus Big Corp in federal court in State B based on diversity. Continuing at line 8, line 11. Line 11. As discovery proceeded, Big Corp disclosed that although it manufactures its own power saws, the particular power saw that allegedly injured Paul had been manufactured in state A. So this saw came from state A. And it continues to say, and that Amcorp had been manufactured by Amcorp. So Amcorp is the corporation over here. So the saw had been manufactured by Amcorp, which is, and that Amcorp is incorporated and headquartered in state A. So Amcorp is over here in state A. Again, they are incorporated in state A, so that's one place of domicile. And the other is their principal place of business, and the principal place of business can be determined either by muscle test or nerve test. And they're giving you the answer to the nerve test here, telling you that Amcorp its headquarters are in state A. And so that's under the nerve test. This is the second place of domicile. If you use a muscle test, we don't know where that would be. You kind of get the impression that it's probably also state A, but you just might mention that you're assuming that this jurisdiction is using the muscle is using the nerve test because you don't know where the muscle is. So they found out, continuing at line 11, we find out that the saw was manufactured over here. Line 13, Amcorp and BigCorp generally conduct business solely in their respective states. So now you know that whether you use the muscle test or the nerve test, that BigCorp's second place of domicile, besides this where it's incorporated, is state B, and the second place here is state A, because they tell you they only do business primarily in their respective states. So Amcorp and BigCorp generally, line 14, conduct business solely in their respective states, but they sell surplus to each other twice a year. So this saw, what happened to the saw then is something like the following. The saw was manufactured here. So this is the saw made here. Then these people, twice per year, the saw went through here and then ended up here. And this is the surplus sales takes place 2 times a year. I put it up here. Sales surplus stuff takes place 2 times per year. So that's how the saw ended up here. Continuing at line 16, Paul sought leave to amend his federal complaint to name Amcorp as a defendant. So Paul has sued BigCorp, and Paul wants to amend his complaint to add Amcorp. So let's see what happens. Line 17, BigCorp opposed the motion, claiming that such a joiner, well, let's put this on the board here first, see what he's opposing. So the second thing that happened here is, let's put this in a different color so we can follow it easily. So the second thing that happened is Paul wants to sue 2 people now. Wants to sue BigCorp and Amcorp. The facts say that at line 17, BigCorp opposed the motion, so BigCorp here opposes this motion on claiming that joinder would defeat diversity. And so it's true. If you, because Amcorp is a state B, this is state B, M Corp is state A, Big Corp is state B, and Paul we know is state A. And so diversity would be destroyed because both Paul and M Corp are from state A. And so Big Corp objects, saying, yes, this would destroy diversity, and at line 18, moves for the dismissal of the action because of the, and this is the key sentence right here, because of the impossibility of joinder of M Corp. That you cannot join M Corp, and they're saying that since Paul cannot join M Corp, it's impossible for Paul to join M Corp, then the case should be dismissed. Impossible to join M Corp, so the case should be dismissed. Now, what is the real rule? Well, the real rule is that indeed Paul cannot join M Corp, but what we have to do is to see how big a deal is it that he cannot join M Corp. We need to see, first of all, is M Corp a, so we'll put a sub item here, is M Corp necessary? And this is, we'll use 19A for this. And secondly, is M Corp indispensable? And we'll use 19B for this. And if M Corp is indispensable and Paul cannot join them, then Paul should be dismissed. But if M Corp is not indispensable, the court should proceed without M Corp. And so that's the basic question that we have to answer. And so how do we decide that? Well, we decide that by going to this board, and over here we say 19A is, and we're asking now, is M Corp necessary? And this is necessary using the language, again, the FRCP 19 doesn't call these people that ought to be in the lawsuit. It doesn't give them a name at all. But by tradition, they've been called necessary, they've been called conditionally necessary, and they've been called people who ought to be in the lawsuit. It doesn't matter which of those you call them. But what 19A says that a person is necessary. One of the reasons a person ought to be in the suit is if it's going to expose a party to inconsistent judgments. And so here, if Paul sues Big Corp, and Big Corp loses, and Big Corp says, okay, I'm going to get my money back from M Corp, and they might not be able to get their money back. So we'll put it here, if, just to be clear, if Big Corp loses, the suit, and if they lose, if Big Corp loses, I guess, against Paul, then Big Corp may not win in the indemnity suit against M Corp. Okay, these are inconsistent judgments. so you can see that Big Corp is saying M Corp is necessary because we, Big Corp, this is Big Corp trying to look out for itself. So Big Corp is saying, you got to sue these people because if we lose, we may not get our money back against M Corp. And therefore, M Corp ought to be in this lawsuit. Well, Big Corp is right. M Corp is a necessary or conditionally necessary person because this could really happen to Big Corp. But the question is, can the court proceed in good conscience without M Corp? And so we go to FRCP 19B, and the question here is, can the court proceed in good conscience without M Corp? And the answer, so can the court proceed in good conscience without M Corp? Because remember, this good conscience is the term of art that's right out of the code. And the answer is, well, yes, the court can proceed in good conscience without M Corp. And the reason they can proceed in good conscience without M Corp is because if Big Corp is really that concerned about inconsistent recovery, inconsistent judgments, Big Corp can solve the problem. Just implead M Corp. Can the court proceed in good conscience without M Corp? The answer is yes. Because Big Corp can implead M Corp. So the answer is yes, because Big Corp can implead M Corp. And then that'll get M Corp into the suit by a different method under Rule 14. This is FRCP 14, by the way. And so the conclusion is that M Corp is not indispensable. I'll put this on the board, our final conclusion. Therefore, is not indispensable. So this is the analysis that you need to be familiar with. Under Rule 19A, we'll run through it quickly. We got 1 minute before the break. The problem here, if we start back on this side, is that Paul wants to amend his complaint so that Paul is now suing Big Corp and M Corp. Big Corp says, no way. See, Big Corp just wants to get out of the lawsuit altogether. So they're saying the court should dismiss the lawsuit because M Corp is indispensable and Paul can't join. That's basically Big Corp's message. Big Corp is saying M Corp is indispensable and Paul cannot join him. Well, we agree Paul cannot join him. But the question is M Corp really indispensable? And to get there, we go to 19A and 19B. 19A is M Corp necessary. 19B, if M Corp is necessary, can we proceed in good conscience without them? Under 19A, we concluded that M Corp does fit the rule and is a person who we call necessary or conditionally necessary or ought to be in the lawsuit. But even though M Corp ought to be in the lawsuit, the court can proceed in good conscience without them because Big Corp can avoid the inconsistent judgment by simply impleading M Corp right now under Rule 14. Therefore, M Corp is not an indispensable party, and the court was incorrect or wrong or in error when it dismissed Paul because of the facts say at line 29 that the federal court dismissed Paul's complaint, and the federal court should Paul can't amend the complaint this way, and so what Paul can't do this, and so the court probably should have dismissed this amended complaint and just left the original complaint against Big Corp, because even though Big Corp is complaining they may be subject to inconsistent recoveries, they can fix that by just impleading Big Corp. So the answer is the court should have dismissed this suit because of the diversity problem, but they should have left this suit and leaving this suit, and then Big Corp is complaining, but Big Corp can fix the problem. Let's take 10 and pick it up from there.